Will Prosecutor be joining us? It is now 11:01 a.m. We are on the record in the 13th Judicial District, the District Court of Greenwood, County, Kansas. Please announce appearances.
The defendant, Mr. Moller, appears in person with counsel Christopher Ambrose, Parvis Legal.
I see a picture of County Attorney Jill Gillette on the screen, and it says County Attorney's Office, but we don't have a prosecutor today.
Judge Jill is in a special setting Elk County trial. She found out on the 15th, 16th that this would be taking place with Judge Ricky, kind of a high-profile case down there. And so we started putting in place the replacement or continuances that might be on contested hearings on the 17th of January. This is the only one that was not resolved.
And Judge, if I may,
Alright, so the person speaking.
Hey, let's stop right there, because this is not how a serious felony hearing should kick off. We're dealing with defendant facing heavy criminal charges. Yet, there's no prosecutor in sight. The judge looks completely blindsided, and you can practically feel her patience running out when one side, especially the state, shows up unprepared or doesn't show at all. It's more than just inconvenient. It makes everyone question how seriously justice is actually being handled.
In Greenwood County 2024 CR 140, State of Kansas versus Wayne Allen Moller. We still have no prosecutor. We do have back with us Chris Ambrose, defense attorney, and the defendant, Mr. Moller. Jessica, what's your official title down there?
Legal assistant, Your Honor.
Thank you. Legal assistant. All right. You know, all the time I've known you down there, I wasn't sure. All right. We have no prosecutor because Miss Gillette is tied up in an Elk County jury trial, correct?
Yes. Started, I believe, this morning at 9 a.m.
All right. Mr. Ambrose, you've had a chance to talk with your client. Are there any new developments from your side of the case?
Your Honor, I spoke with him, and in light of kind of the situation Ms. Gillette's found herself in, we don't have an objection to continuing this. If we could just get a new date set, and hopefully Jessica will be able to have a calendar so we can get that set. I'd like to make sure that we have it set for an evidentiary.
Here's the interesting part. Notice how even the defense attorney isn't trying to exploit the situation. He could have easily demanded a dismissal or pushed for a sloppy preliminary hearing. But instead, he requests a continuance because no one wants a rush case that ends up getting overturned later. Even with that cooperation, though, the judge's frustration is obvious. She's not mad at the defense or the stand-in assistant. Her real issue is with a breakdown in the system, caused entirely by the prosecutor's lack of professional.
Time's long docket.
Well, we better not just have a status conference. I had this set for evidentiary hearing again since November 22nd, 2 months ago. And then they come in and a few minutes before court and I'm told that, the county attorney continued at 5 days ago without consulting the court. I think it's unfortunate that Ms. Gillette is supposed to be in 2 courts at once, but that was the responsibility she took on when she ran for county attorney in both Elk and Greenwood County. She certainly gave the appearance that she could take care of both of us as needed. And now I've been bumped for something going on in Greenwood County. Surely a pro tem could have been called for. I know Judge Hutchison used to appear as a pro tem, retired Judge Hutchison. Mary Ann Shirley, local attorney, has done that. Miss Oliver, who I understand has lots of experience in various counties as prosecutor, assistant prosecutor, was here just an hour ago in a case. And Assistant County Paul Dean helped cover the cases. So I'm just really put off that, first of all, as a prosecutor would take it upon herself to just decide she didn't have to be here and she didn't have to talk to the judge about it or work it out. This case involves very serious charges. Count 1 is unlawful distribution of controlled substance. The defendant is accused of a level 2 drug felony allegedly possessing back on July 26, 2024, approximately 54 grams of the controlled substance methamphetamines. In count 2, he is accused of on that date also possessing fentanyl, a level 5 drug. In count 3, he is accused of possessing paraphernalia to help manufacture, cultivate, plant, propagate, harvest, test, analyze, and distribute controlled substance. Count 4, he's accused of an aggravated weapons violation by possessing an AR platform rifle while having been convicted of a person felony under Kansas law and an aggravated battery case.
Where the mood completely shifts. As the judge starts reading out the charges, meth distribution, fentanyl possession, tampering with firearms, and a restricted AR rifle, the weight of it all hits. These aren't minor violations. This is serious stuff that threatens public safety and the community at large. So, you can imagine her irritation. A high-stakes case like this was almost derailed simply because no one bothered to alert the court or arrange a backup prosecutor.
Subpoenas, does anyone know?
No, ma'am. They would be available if I need them. They're just on standby.
All right, so they were told to be on standby, but not necessarily be here. All right, thank you for that info. Well, I'd like to call them from standby and start this hearing. You don't have any prosecutor available. No, Ms. Gillette didn't arrange for any prosecutor to be here?
It was my understanding she did not want to impose on another prosecutor to do a contested hearing. She didn't feel comfortable with that. Since these are her charges, she filed them. She wanted to be the one to potentially present the evidence to you herself. Because Miss Oliver is actually covering the rest of the things today that aren't contested. This was a Miss Gillette decision. We just tried to follow through and get it disposed of before 11.
God forbid we'd impose on a prosecutor pro tem that's reserved and not think twice about imposing on a judge or a defense attorney or a defendant. I don't know why it would be that Miss Oliver, who is experienced, would be more inconvenienced than any of the rest of us. But again,
This moment goes beyond simple courtroom frustration. It's a wake-up call. The judge is basically saying, if you want the responsibility of being a county attorney in more than one jurisdiction, then you don't get to disappear when things get inconvenient. Judges don't usually call out prosecutors in open court unless something's seriously wrong. She's not just postponing the case. She's setting a boundary. This courtroom demands respect, and she's making that perfectly clear.
Is the next available evidentiary hearing date that you have, because this defendant and his attorney are entitled to an evidentiary hearing.
What about Friday, February 7th? I have 11 o'clock or I have some time in the afternoon.
Mr. Ambrose, do any of those work for you? Or either of them?
What was that date again, Missy? Sorry.
February 6th.
Could we look at the afternoon that day? Do you have anything after 2?
Or actually completely open in the afternoon, so we could do 2 o'clock.
Could we do 2:30 just out of an abundance of caution?
Yeah.
If that would be possible. I'm sorry, I'm in Geary County later that morning. I've got you guys first thing in the morning. I've got Geary after that, and I'd like to be able to drive back to Emporia so I'm not stuck in Geary County until the end of the day and then driving in the dark because I'm an old.
2:30 works for Jill.
All right. If that works, I want to make sure you have plenty of time so you don't get penalized for this situation we had today.
No, that'll give me enough time, Judge. That means I have to be out of Junction City by 1 to be back to my office in time, so that's fine.
One thing for sure, the tone from this point on has completely shifted. The defendant still faces every one of those serious charges, but now the prosecution walks in with a credibility problem. And the judge? She just sent a powerful message. You can be late on time, but not late on accountability. What do you think? Did the judge go too far, or was she right to draw the